You're a business owner. You just heard about the new Corporate Transparency Act and are wondering whether you can bury your head in the sand or not. Well, dig yourself out. You're in the right place because today you're going to learn how to determine if your company needs to comply with the CTA and its new reporting requirements. Hey guys, I'm Misha. I'm an entrepreneur and an attorney licensed to practice in New York and Florida. I'm an attorney, but I'm not your attorney. So this is for informational purposes only. If you have questions specific to your situation, you should reach out to counsel in your area. Okay, so in the last video, you learned about the Corporate Transparency Act in broad strokes. Today, I want to give you the resources to determine whether your company needs to comply with this new law. You'll remember that under the CTA, starting in January 2024, an estimated 33 million businesses in the US will have to start disclosing their information about who owns and controls their businesses to the federal government. The information disclosed is supposedly going to help deter and combat financial crimes rooted in corporate privacy. Well, despite our feelings about the CTA, the administrative burden that will be necessary to comply with it, or the privacy and disclosure concerns for the information reported, at the end of the day, all businesses that are reporting companies will need to comply with the CTA's reporting requirements or risk hefty penalties for noncompliance. So let's get into it. The first step in figuring out whether the CTA impacts your business is determining whether your business is a reporting company. Only reporting companies need to comply with the CTA. A reporting company is defined as any entity that meets the reporting company definition and does not qualify for an exemption. There are two categories of reporting companies: a domestic reporting company and a foreign reporting company. If your company is neither domestic or foreign because it doesn't meet the definition, or if it qualifies for an exemption, then it's not required to file a beneficial ownership information report with FinCEN. So let's look at the definitions and exemptions to see if your business will need to file a report. Domestic reporting companies are corporations, LLCs, limited liability companies, and any other entities created by the filing of a document with a Secretary of State or any similar office in the United States. A foreign reporting company is an entity like corporation or LLC formed under the law of a foreign country, but has registered to do business in the US by the filing of a document with the Secretary of State or any similar office. So if you've ever used LegalZoom or some other company that incorporates your business for you, or if you've done it yourself by going online to your state's Department of Corporations or Secretary of State's website and completed a form and made payment to register your business, then you meet the definition of a reporting company. Sorry. Whether you filed a document with a government agency to start your business is a fairly easy question to answer. And for most of you, the answer will be yes. Yes, you are a reporting company. Now, there are 23 types of entities that are exempt from the reporting requirement. An entity that qualifies for any of these exemptions is not required to submit a report to FinCEN. So here, you'll see that the majority of these exemptions are for entities that are already highly regulated. So for example, we see multiple exemptions for financial related entities, securities, banks, credit unions, investment companies, Also exemptions for insurance-related entities, insurance companies, insurance producers. And we also see exemptions for categories like public utilities and tax-exempt entities. But what's important for us to look at are a couple of exemptions that small and medium-sized businesses would most likely qualify for either now or at some point in the future. The first exemption that we'll take a closer look at is for large operating companies. To qualify for this exemption, an entity must meet 6 criteria, all 6 criteria, okay? So the first one is the entity employs more than 20 full-time employees. And generally, a full-time employee means an employee that in a calendar month works an average of at least 30 hours per week. The second criteria is those more than 20 full-time employees of the entity are employed in the United States. Third criteria, the entity has an operating presence at a physical office within the United States. So an operating presence at a physical office within the United States means that an entity regularly conducts its business at a physical location in the United States that the entity either owns or leases, and that is physically distinct from the place of business of any other unaffiliated entity. Let's think about this. So, all the virtual companies out there, right? Your virtual business, you don't have a brick and mortar physical office that you regularly conduct business at. That would knock you out of contention. Okay. If you have a business that you only run out of a shared space, like a WeWork or a community office where there are other businesses that also work from that location, that'll knock you out of this criteria point. Okay, so you have to have a physical location that you either own or rent, and that no other business shares with you, basically. Fourth criteria, the entity filed a federal income tax or information return in the US for the previous year showing more than $5 million in gross receipts or sales. That's pretty easy to answer. The fifth criteria, the entity that reported the more than $5 million amount in gross receipts or sales, they reported it on an IRS Form 1120, Consolidated Form 1120, Form 1065, or other applicable IRS form. And the last criteria is the gross receipts and sales that we're talking about that are over the $5 million. None of that comes from foreign sales. So if you exclude any foreign sales from that gross receipts or sales amount, it will still be over that $5 million threshold. So we see the criteria for the large operating company exemption has quite a few points that may exclude a lot of small or medium-sized businesses. But if you have a growing business, you're adding employees, you're becoming more profitable, you're buying or renting physical office space, this is an exemption that could apply in the future. Now, before we look at the other exemption, if you are getting good information from this video, why not go ahead and hit that like button and subscribe to this channel? I'm trying to get these videos in front of as many people as possible because mainstream media and even social media is doing a poor job of sharing this information. This new law, the CTA, is impacting approximately 33 million businesses, and studies are showing that the majority of those impacted have never even heard of the CTA. So share this video, like, subscribe, leave comments so that YouTube will see the engagement and suggest it to more people. All right. So the other exemption that we need to look at is for inactive entities. If a reporting company meets the criteria for an inactive entity, then it won't have to file a report with FinCEN. There are 6 criteria, again, that must all be met in order to meet the definition of an inactive entity. First criteria, the entity was in existence on or before January 1st, 2020. 2, the entity is not engaged in active business. So to me, that's saying the entity is not currently engaged in any active business. 3, the entity is not owned by a foreign person directly or indirectly, wholly or in any part. And a foreign person means a person who is not a United States citizen or resident of the US. It's not a domestic partnership or corporation, and other estate or trust of a US citizen or resident of the US. 4, the entity has not experienced any change in ownership in the preceding 12-month period. 5, the entity has not sent or received any funds in any amount greater than $1,000 directly or through any financial account in which the entity or any affiliate of the entity has an interest in the preceding 12-month period. So we're going to have a 12-month look back period to see in the past 12 months, have you sent or received more than $1,000? If you have, then you cannot qualify as an inactive entity. And the last criteria to meet the definition of an inactive entity is the entity does not otherwise hold any kind of asset, whether it's in the US or abroad. The entity is not an owner. It doesn't have an ownership interest in any other entity. Okay, so we see the criteria for being an inactive entity is a bit more involved than what you may have imagined, right? People who assume their business is an inactive entity really need to review the criteria to determine if they actually meet it. Because if they don't and just decide to ignore their reporting requirements, it could come back to haunt them, given the pretty stiff penalties for noncompliance. Saying I thought, or I assumed, or I never would have imagined, without actually going through the exercise of confirming your thoughts or assumptions is not going to work as an excuse for noncompliance. So there you have it. You've seen how to determine if you are a reporting company, and if you are, if any exemption applies to your business. I hope this was helpful. I hope you got some good information. If you have general questions about this, leave them in a comment below. I'll do my best to answer them. If you'd like to keep abreast of developments with the rollout of this new law, there's a lot of movement. There's a lot of updates. There's a lot of changes, and some changes are substantive. Hit that subscribe button. Stay tuned. I will be bringing you more information about this law, about how to figure out how to comply with it. Now, if today you figured out that you are a reporting company and no exemption applies to you, the next step for you to take is identifying your business's beneficial owners. The beneficial owners are the people that you're going to have to disclose to FinCEN as part of this reporting requirement. So watch the next video to see what that exactly means and how to do it.